forward us an email, but is, as far as I understand, still proceeding with us. So, as I say, we're missing a juror, but I understand also that there's some things you guys want to talk about, so maybe we can do that while we're waiting that juror to get here.
Sure. Your Honor, good morning. We had a few issues that the state wanted to raise. First of all, with respect to the opening slides that defense counsel has given us, we do have a concern about slide number 9 in particular that this one has, which is basically just the slide of Sarah McDowell's email in which she says that she's lying to get on the stand. The state's concern is that, as you know, this is an opening statement, and as the court cautioned last week, this isn't a closing argument or an opportunity to make closing argument. I don't see any argument that could be made or any statement that could be made with respect to this. It wouldn't just be argument with respect to Ms. McDowell's credibility. And so, we're raising that, and we obviously will object throughout opening if necessary, to the extent that all defense counsel does is argue the case, which it seems like from the slides that they have presented, that's what they intend to do. But we wanted to raise it before, because I don't think that there's any basis on which to, unless counsel wants to enlighten us with respect to what he's going to say about what the defense intends to prove going forward with respect to this particular slide. So that was my issue there. I don't know if you want me just to go on to my other issues, or you want to take one at a time.
Was there any other issue about the PowerPoint?
No. That was
Okay, so that's, we'll start there then. Mr. Arbenz, care to comment?
Your Honor, it's a admitted exhibit. I understand how to give an open statement, so if the state wants to object, they certainly should, but it's just a fact that I'm going to talk about.
Well, certainly, Ms. Eakes is right in that we don't want to hear argument, but as lawyers sometimes put it, a roadmap of facts for an opening statement. If you stay with that, that'll be fine. Next issue, Ms. Eakes.
Second issue, Your Honor, is with respect to the defense advised us on Saturday that they intend to call a witness by the name of Cody Pollock. Mr. Pollock's involvement, as far as you can tell, and I'll hand this over to the court, is he was the provider, one of the providers at Good Samaritan Hospital following the 2019 incident. And you can see from the entry that I've provided to the court that essentially he was the tech who was cleaning Mr. Ellis's wounds when he says that he woke up and he aggressively postured at him with his fists clenched. He says he was able to kind of talk him down. He explained the process and the procedure of cleaning the wounds. And the patient was more calm with the tech when he was cleaning the rest of the wounds. We don't think that this is relevant. Our understanding of the court's ruling with respect to 2019 was that the court was primarily letting it in as it went to Mr. Ellis's interaction with the police when he's purportedly in a meth psychosis. This is 404B evidence. These officers had no knowledge of this information, and under 403 it would be more prejudicial than probative. It really has no probative value as to this particular incident, other than the defense attempts to show that Mr. Ellis is aggressive, violent, not a good person, I guess I would say. So we object to the defense calling Mr. Pollock on this particular issue.
Morning, Judge.
Mr. Conrad.
So the pertinent aspect of Cody's testimony is not only the fact of how Mr. Ellis acts while he's on methamphetamine. It doesn't have to do with Mr. Ellis's character in that regard, right? It's how methamphetamine affects this individual. And what the state is, I think, failing to recognize with Cody and with this incident is that what worked with Mr. Ellis in that scenario was 2 shots of Ativan or lorazepam that helped calm him down in that scenario, and that's something that worked with him in that particular circumstance. So, I mean, that is the relevant aspect of the interaction there, is not only the fact that Mr. Ellis is high on methamphetamine, reacts in an aggressive way, but what worked in that scenario was chemical restraint.
Your Honor, we don't see how chemical restraint, even if it were true that he had Ativan and lorazepam, this witness doesn't say that, and he's not qualified to give that medical intervention. He's an emergency service technician, but also that's simply not relevant to any issues in this case. I mean, I don't, this is after the fact of the hospital, and you can see from the entry that, and there are many other entries which indicate that Mr. Ellis was cooperative. When they put him through a CT scan, when he had a number of scans, he had 4 major injuries to his head that all had to be stitched up. And the only incident that we have here that indicates that he was in any way anything less than cooperative is this one where he's sleeping and he wakes up to this tech cleaning his wound. All the rest of the medical records indicate that he was cooperative and coherent throughout. So it doesn't really, I mean, and the defense counsel knows that. I can show the court the rest of the records. There's no, it really shows nothing other than, as I said, some type of character evidence for Mr. Ellis.
The note says additional meds were ordered. So I take it, Mr. Pollock, did he actually administer the medications?
No, it's the doctor that is assisting, well, that's part of the care team that evening. We have the medical records, it states exhibits 981.
Well, it says here that Mr. Pollock is an emergency service technician. Is he a physician?
He's not a physician.
Okay, I thought you said he was a doctor just now.
No, so the doctor is the one who ends up prescribing it, ordering it, but it's at
Right.
the behest of, obviously, this interaction with Mr. Pollock.
So Mr. Pollock contacts the doctor and says, we need to get some meds in this guy.
Says, hey, this
Something
guy's-
like this.
Yeah, something like that. And I mean, these are medical records, right? And I handed up a number of declarations to the court, and I think that hopefully the court has an opportunity to review them.
I saw them.
Under 1096, I think it's 030, these records have been certified by a records custodian. That declaration has been provided to the state in, I think, beginning of September, end of August. It meets all the qualifications. I think it's, let me pull up the statute real quick. So it says, so on 1096.030, it says, to be admissible without testimony of the custodian of records, business records must be accompanied by an affidavit, a declaration, or certification by its records custodian or other qualified person that includes contact information for the witness, completing the document and test the following. The witness is a custodian of the record and sets forth evidence that the witness is qualified to testify about the record. The record was made at or near the time of the act, condition, or event as set forth by the record. The record was made in the regular course of business. The identity of the record and the mode of preparation, and either the record is the original or it's a duplicate that accurately reproduces the original. A party intending to offer a record into evidence under this section must provide written notice of that intention to all adverse parties and must make the record an affidavit, declaration, or certification available for inspection sufficiently in advance of their offer into evidence and provide an adverse party with a fair opportunity to challenge them. A motion opposing admission in evidence of the record shall be made and determined by the court before trial and with sufficient time to allow the party offering the record time, if the motion is granted, to produce the custodian of the record or other qualified person at trial without creating hardship on the party or the custodian or other qualified person. And again, this is authenticity of records, specifically applies to criminal process and criminal cases. So I haven't received any objection to the declarations. The declarations meet those specific requirements. So to the extent that these are medical records that Mr. Pollock is a part of, he relies upon them as well. They've been certified. He can testify about what's in them, including that 2 doses of lorazepam. One at the outset of Mr. Ellis's care was given, and then after this interaction, there was another dose that was given to him again to help him again calm down. And what's also significant in here are the injuries that he sustained. I mean, he sustained significant head trauma and injuries during this interaction with the A&W staff. And so, there's a number of notations, I think, in the autopsy report, and you see scars on his head. There's a notation about his chipped tooth, which occurred during this incident, not the 2020 incident. And so, it not only is it the behavior of Mr. Ellis during this incident, what worked in terms of chemical restraint, but the injuries that he sustained, which were significant during this incident as well.
Your Honor, I mean, just because they meet the statute or counsel is trying to offer them, they still have to find that they're relevant. Mr. Ellis is not on trial here. And the conduct that we're talking about is completely detached from the 2020 incident that the defendants are on trial for here. The idea that they need to put this in order to show that he had some injury that resulted in scars on his head is ludicrous. I mean, it's not in any way relevant to this, and nobody testified, nor was there an issue for purposes of the 2020 and his death about whether or not there was another scar on his forehead. So again, I don't think that there's any relevance to this information, and it is prior character evidence. Just because Mr. Ellis was the victim in this case does not mean that the defense gets to come in and put in all of his medical history from all other prior treatments or incidences. And this one simply has no relevance, and this witness has no knowledge of anything that happened in 2020. As an emergency service tech, I mean, they're essentially asking him to testify to medical records, even though he's not permitted to prescribe nor to administer the medications himself. I'd also note that this witness was disclosed last Tuesday for the first time, and we did attempt to interview him. Yesterday, he was willing to speak to us if defense counsel would be present on the call, and I attempted to reach out to defense counsel and never received a response to my email asking if they would join the call so that we could speak to Mr. Paul. So, but the primary issue is that I don't think it's relevant, and it's 404B evidence, and under 403, the court should exclude it.
You emailed me last night and asked what time I'm available this evening, on a Sunday evening, to be available for a defense interview. I wasn't available. I'm happy to be available this morning if you want to talk with Mr. Pollack, but...
And the reason I did that, Your Honor, is because we didn't receive any contact information from Mr. Pollack other than Good Samaritan Hospital, and so we had to track him down in order to try to get him. So.
Good. This information, the Good Samaritan Hospital records are something the state has had for months, if not over a year.
What's that got to do with contacting Mr. Pollack?
Well, because all he's going to testify to is what occurred during this incident. So they know what the information is. They know who he is. We've listed I mean, there's so many different providers that cared for Mr. Ellis over the years. It's difficult to name every single one of them. I mean, we could also call him the doctor if we want to call him the doctor. But I have a records declaration. They're admissible under the business records exception pursuant to that declaration, and he can testify about what is included within those records, whether he administered the shot of lorazepam or it was ordered by someone else. There are records that he relies upon regularly, and he's there for the incident.
Well, as far as interviewing Mr. Pollack, you can certainly do that whenever he arrives here. It doesn't sound like he's going to be a lengthy witness. Ms. Eakes makes a point that Mr. Ellis was perfectly fine with everybody in terms of other procedures except for this incident, and you're suggesting that he was fine in part because he was medicated?
He gets medicated, right? If you look at the medical records, he gets medicated at the forefront of when he comes in.
Mm-hmm. And that's why it says additional meds are ordered?
He gets one shot of lorazepam at 9:56 p.m., and then he gets a second shot at 10:27 p.m. And it's 2 1 milligram doses of lorazepam in order to calm him down.
What does it say to calm him down? I mean, Mr. Ellis suffered...
What does lorazepam do to an individual?
Well, counsel's suggesting that he knows what these things are about. Mr. Ellis suffered a severe head injury, and they had to stitch up his head in 4 different locations, and he had to have 3 separate scans. So the fact that he might have received some lorazepam in order to put stitches in his head in 4 different locations is not evidence that somehow this is related to meth, is the reason why he had to have that medication. And I would note, Your Honor, that the court has found that nothing Mr. Ellis did in, the day essentially of his death leading up until hours before is not relevant. And so it's hard for the state to understand how something that happened in 2019 at a doctor visit or at the hospital when he's being treated for something unrelated is somehow relevant to the events that occurred here.
Well,
Particularly since he had been in the hospital for a period of time before this interaction. He had come in sometime before this interaction, which is noted to have occurred at 2319.
right, I don't know if it happened at 2319 or the earlier couple of times that are mentioned by Mr. Conrad, but it does seem to me that this was part of his reaction to the methamphetamine he was taking. That's why it links back to our case. And yes, times on the day in question here in March of 2020 that occurred before he evidently used methamphetamine would have little to do with anything. So that's why it's not particularly relevant.
Well, I would just say that depends on, of course, something that is unknown, which is what time Mr. Ellis did in fact use methamphetamine.
Right, but all the folks you wanted to say said, well, he didn't use methamphetamine that I know of, and yet we know that that isn't true.
Well, I think that
Not that they're lying, but merely that they wouldn't have, that it may well have occurred at a time when they wouldn't have observed him.
Well, that depends on whether or not the amount that he took, he could have been taking it earlier in the day in smaller amounts, for example, and that it did not show a demonstrable effect on him.
Well, I suppose that's possible, except for the fact that the testimony we have, even from your witness, indicates that the metabolic outcome of amphetamine that was found also in his blood supply was such a small amount as to suggest that he had not metabolized much of the methamphetamine, which suggests that he had not used it too long before this incident.
It doesn't preclude the possibility that he used earlier in the day, and that metabolite was already gone, and that he then used later, and that was the metabolite that was seen at the time. I mean, I think that there's just a lot of misinformation with respect to.
Well, that's all just fantasy unless you've got somebody that can support it. The people you were talking about were going to say, well, the one person you said was going to say that he had confessed to having relapsed that occurred a few days before all this. You chose to withdraw, but certainly indication that he hadn't been using doesn't tell me anything about a time when he had in fact been using, which is what this time was in September of 2019 as well.
Well, that's correct, Your Honor, but I understood from the court's prior ruling that you're not going to allow the defense to go down every time Mr. Ellis is using methamphetamine. And frankly,
No.
based on the series of records that are here, there's no indication that this waking up and posturing was somehow related to the methamphetamine. That's the fallacy of the argument that's being made here, and that the court's accepting, is that this interaction, so his other interactions earlier when he's cooperative and he's responsive and he's going through all of the treatment, that's happened while he's on methamphetamine, but then this one is supposedly evidence of the reaction he has to
I suppose you guys can get into all that if you want to. I suspect that what Mr. Conrad's going to say is he was calm earlier because he had been administered medication to calm him down, but there you go. If there was an indication in the records that the medication was prescribed because of trying to reduce pain while Mr. Ellis was being treated, well, then you've got a point about it not being relevant. But if it was administered in order to change his mood and aggression, then the defense has the point. And here, the note that I've got, and I don't have any of these other medical records, so I'm talking in an abundance of ignorance here to some extent, but it says, while cleaning patient wounds, patient woke up, aggressively postured at the technician with fists clenched. The tech was able to talk the patient down while Pierce County Sheriff entered the room. This tech explained the process and to the patient, the procedure of me clearing out his wounds, what was required of the patient. RN was consulted, additional meds were ordered. Patient was more calm with his tech while cleaning out the wounds. Now, maybe he simply calmed down by being talked to him. Maybe he was, because it isn't clear when the meds were ordered. It could be that the other meds wore off. I mean, there's all kinds of possibilities here. I don't know what they are, but to the extent we're talking about aggression on the night of the event with the A&W folks, and it well as I suppose could be interpreted as a fair inference as a product of his aggression because of the methamphetamine use, which at least is the claim that defense is making as to his conduct earlier on that day. As with respect to the wounds, I'm not, certainly the chipped teeth is an issue because it was brought up during the course of the testimony by the forensic medical examiner that the state offered. Now, it was mentioned in cross-examination, but that doesn't make it evidence, so they could still bring that up. As for other wounds, if you're just going to talk about lots of other wounds, I don't know what that has to do with unless it's to explain certain scarring or evidences of injury on Mr. Ellis's body at the time of the autopsy that would be explained by this event rather than the event on March 3rd. What would the point of it be otherwise, Mr. Conrad? As I say, I know about the chipped tooth, but beyond, is there some other wound that would still been observable that wouldn't have been obviously an old wound to somebody, Dr. Clark, the county medical examiner?
No, Your Honor, that's fair.
All right, so I don't see we need to go into that at all.
I guess the only thing that comes to mind is when officers initially interact with him, he's already pretty severely injured from the altercation with A&W. But I mean, the officers.
What do you mean by that?
Like he's got head wounds, significant head trauma from the A&W incident when officers first arrive as well.
On March 3rd?
No, sorry, on the September incident.
September 21st?
Sure. So when they're encountering him, he's already severely injured, and he still puts up a pretty good fight. I'm not going to go there with Mr. Pollock. I don't think there's a need to. I just wanted to ask him about that entry that he made, and that's it.
Well, as I say, I think you can ask Mr. Pollock about this. As for the injuries, I guess we'll see, but I'm not seeing any reason to go into them generally. I mean, I think the injury thing is kind of cuts in two directions. If somebody's just punched me out, I might be more combative with anybody else that approaches me too. Which would not be explained by my methamphetamine use, would be explained by the fact that somebody has already injured me once this evening. I'm not going to stand for it twice, so. Okay. Mrs. Winnie, do we know anything about our jurors? And is there, everybody's here now? Okay. Is there anybody else, any other motions before the jury comes out? Mr. Fricke, you're raising a finger, I see.
We do.
Oh.
Sorry. We had two other issues still, Your Honor.
Okay.
Also, the defense has indicated that they intend to call Byron Jones as a witness today. Mr. Jones was working at the A&W in September of 2019. Again, we don't believe that the underlying events at the A&W are relevant. Our understanding is that the court allowed 2019 to show some form of, response by Mr. Ellis to police when he's reportedly on methamphetamine. This is, again, is 404B evidence. We think it should be excluded under ER 403. I don't think the court was always entirely clear with respect to whether or not you were going to let in witnesses from the underlying incident. We raised this in the initial briefing about there kind of being mini trials on this, and Mr. Jones is specifically a witness with respect to the underlying A&W incident. So,
Who is going to call Mr. Jones?
Officer ranking again. So, Judge, the witnesses from the state said that Mr. Ellis was attacked, like he was beat up by the A&W staff. For, no apparent
You mean like
reason.
his sister and his mother?
Yeah,
Testified along those lines?
correct.
Yeah.
Byron Jones will testify that he's the shift manager that night, and that a man came in with his shirt off and a belt wrapped around his hand and said, "Give me all the money out of the drawer," and tried to jump over the countertop, and that he pushed him off. There was some scuffle that ensued. He didn't know what happened, and that individual fled, and they had called the police, and that's it. And that's what police wrote.
Your Honor, I would just note that the defense counsel brought out statements with respect to the 2019 visit, not the state. So they can't kind of set it up by asking the questions of those witnesses. We didn't ask his mother or his sister about the September 2019 incident and what statements Mr. Ellis made. The defense did. And then to say now we get to call the underlying witnesses in order to say something contrary to that. They chose to open the door on that, and they have the answers based on what they understood. But I don't think that otherwise it's admissible.
Well, my notes reflect that when Mr. Ellis's mother, Miss Patterson, testified, she didn't say much about the September 2019 incident. She was asked about it by Mr. Arbenz on direct. And indicated that Mr. Ellis said he was there to use the phone and did not say who beat him up, as my note says. When Miss Carter Mixon, Mr. Ellis's sister, testified, she was asked about this in general and on direct, in that she was aware of the September 2019 incident.
I believe my questions were around
That he was not living with her at the time and began residing with her in October. And they moved out later, and my note says January 2020, later on, I think she maybe made it clear that it was shortly before Christmas, maybe. Well, in any event. And that it was on cross-examination about whether she had watched a video of the 2019 event. And that Mr. Ellis had told her that people at the restaurant had attacked him. And then she talked about Mr. Ellis being confronted by her brother and her mother, concerned about Mr. Ellis's addiction, and thought it was related to a mental health issue, that he was suppressing his mental health concerns with drug use, and that she told him she thought this would lead to his death if he didn't change. But it does seem to me that Miss Eakes' version that the people at the restaurant had attacked him, I suppose, really was brought up by the defense, although the 2019 incident at all had been brought up by the state. So now, Ms. Eakes, you have a comment.
No, I think the court correctly recounted it, and my questions about 2019 were only whether or not he was living with her at the time that incident occurred. So, but it sounds like the court found that testimony.
Yeah, the 2019 incident would have, clearly was a trigger for a number of things that happened. I mean, in the sense that that's why he was involved with the legal system at that moment, at least, that he was in the, apparently in the program for trying to get away from drugs, and that he was also getting mental health treatment. That all those things were bound up of a response to the 2019 event, which were all having its influence when we had the March 2020 event. So, having set this thing up about all that, should the defense now be allowed to bring out Mr. Jones to sort of contradict Ms. Carter-Mixon?
Your Honor, respectfully, the state has put on a fair amount of evidence from the Ellis family how methamphetamine caused him to become quiet and sedated, introspective almost, not somebody who goes the other direction. And that's what this evidence shows, that using meth to some degree, he becomes irate, violent, irrational, which is what happened here at the A&W. So they brought it up that he was this peaceful meth user, not us. And so this shows that he acts differently when he's on methamphetamine.
Well, you're going to get to that anyway. I'm not sure how effectively we're going to be able to sort of parse this out of things, because I'm imagining that even if you just call the sheriff's officers who responded to this thing to at least authenticate the video, if nothing else, that they're going to have some testimony with respect to what brought them there. So I don't know how you avoid that, Ms. Eakes, even if they just said, well, dispatch told us, I'm not sure what dispatch told them, but told them something about this incident, I'm sure, that there had been an attempted robbery, and that there had been some issue with the folks that were there, or that the officer are going to say, Mr. Ellis was, I'm assuming he was bleeding when they encountered him because of the injuries that had occurred with the A&W employees, and so explains to some extent his physical condition when Pierce County Sheriff's officers confronted Mr. Ellis in 2019. So I don't know how we sanitize that out of this, although I tend to agree with you that this defense, having teed this up to some extent, their reaction is, well, the state teed it up by suggesting that Mr. Ellis was a perfectly reasonable guy, even on methamphetamine, and that people like his mother, for instance, didn't realize Mr. Ellis was even using methamphetamine, even though he'd been using it for years, it appears.
And that goes to her credibility, obviously, but I mean, State was not suggesting.
No, it isn't that, it is, of course, it isn't that she's not credible in the sense of her not telling the truth. It may be that she's not credible in the sense that Mr. Ellis was successful in keeping from her these facts, so she wouldn't know.
Understood, but the issue here is whether or not they should get to put in the witnesses on the underlying incident. And the court may be right that that's what they're going to do with respect to the officers, but that's wholly different than proving the underlying, putting on witnesses to talk about the underlying incident.
Are you guys calling,
And the court's
Sorry.
ruling, as we understood it, is the only reason this is admissible, because it is 404B evidence, is to show what reaction he has to law enforcement,
Well,
not to show that Mr.
and
Ellis-
methamphetamine?
Well, I guess maybe now I understand that the court is saying that anytime he's on methamphetamine, and whatever his reaction is, that the court thinks that that's admissible.
Well, I love the
But
lawyers
that's
set up
not-
straw man arguments. That's not what my ruling was, but I always made it clear, whether you understood it or not, I don't know, but I made it very clear that his actions on methamphetamine, as being aggressive and so on, would have a big impact. And I talked about some of the other cases when at least on one case, the Court of Appeals said, you can't put this evidence in because you don't have any evidence about somebody's drug use, because you don't have any evidence of what this person's like on those drugs. And then there was another time it was criticized just the other way around. So,
Well, Your Honor, I think that, again, we're back to who's on trial here? Mr. Ellis?
well, we're not going to revisit whether the September 19, 2019 is going to get in here. My question now to the defense is, how far are you going with this? Is it just Mr. Jones, or are you going to call somebody else?
Just Mr. Jones,
Again, it's, whether they call the officers and the reaction to that is different than calling Mr. Jones. But I think that, I understand the scope of what the court is saying, but does that mean, well, I guess I won't address that right now, but we'll see what the witnesses have to say with respect to these underlying incidences. But I think that it's concerning, it's gonna devolve into many trials, and frankly, Mr. Ellis isn't here to defend himself, as we all know.
Well, when I made this ruling, Ms. Nicolavo told me, well, I guess we're going to have to call another 15 witnesses or so, because we're going to have to show what Mr. Ellis is really like on methamphetamines. I don't know. But in any event, what you propose is showing witnesses who would say what Mr. Ellis was like when he was not on methamphetamine. And of course, that has no relevance to all of this.
Well, I think it's, well, I'm not gonna argue with the court.
Good.
I think the court heard what the testimony was with respect to his sister and whether she's seen him on that.
This is a little more tangential, but it's there, it's nevertheless out there too, which is the argument that's been made here, at least by the defense in their statements that we've heard already, that were offered in the state's case, had to do with this idea that Mr. Ellis was potentially involved with some kind of approach to somebody, whether it was a carjacking or a theft, or maybe it was a friend of his or whatever, that there was at least some contact with somebody in an automobile on the street, possibly for criminal reasons, maybe completely innocent. And of course, one of the reasons the officers were asking about it is because here he was in the street and it looked funny, and what's going on here? Without necessarily being able to conclude anything much one way or the other about it. But in the September incident, of course, there was a prelude to the officers' involvement, which was evidently the attempted robbery of the I&W store, which has at least some parallel here.
So and I just wanna make sure I'm clear what the court's saying, that the court's saying that when Pierce County contacts him in 2019, because they had a legal basis to do it, that makes it more likely that these Tacoma officers had a reason to contact him? Is that what the basis is for allowing that?
No, that's not exactly my point. And as I say, I'm offering this as a kind of afterthought, but it is that Mr. Ellis may have been prone to engage in a robbery in 2020 that didn't get very far because the police were right there, just as he was attempted to engage in a robbery which didn't get too far because of the resistance of the NW workers.
I think that's considered propensity evidence, Your Honor. And
Well, the thing is that you've argued propensity evidence from the beginning on this, and I understand that in general, would be right. But here we have the co-concurrence of the methamphetamine use, which would suggest that under methamphetamines, Mr. Ellis is potentially doing things he wouldn't otherwise do.
Understood, Your Honor. I think the court's also, well, I think we had eyewitnesses who say something different than what the defendant's statements are. But if that's the court's ruling that the
Well,
defense
as I
is
said,
put on, that's
it-
what we understand.
We did have some testimony, which has been pointed out this morning, that I guess it was from Miss Carter Mixon, I think. I think that's where I heard this. That on methamphetamine, he tended to sort of mellow out, I think was the word.
And I think we have one other issue, Your Honor, that Ms. Nicolabo's going to take up.
Okay,
Your Honor, defense advised that they're going to call Deputy Bull and Deputy Wolf regarding the 2019 incidents. And I believe they're also going to be offering the A&W, or the video from, that was pulled off the internet. If they're not offering that, I won't address this issue, but if they are offering that, the state would object to the audio of that video. The individual who recorded it, it's not going to witness or is not here to testify. The video itself, I believe they can authenticate basically that it depicts what the officers observed. So I don't have an objection to the video itself coming in.
well, who made this video?
Some bystander,
Oh, okay.
and then it got put up on a social media site. But based on the court's ruling.
Is that your only video of this event? Okay, I'm sorry, go ahead, Mr. Colombo.
Based on the court's ruling that the 2019 incident is coming in, I think they can admit the video, but the audio that accompanies the video we would object to.
The audio? I don't know anything, I haven't seen or heard this video, so I have no idea.
Well, the only thing that's said in the audio, well, first of all, the audio is particularly important because you can hear Mr. Ellis in it and what he sounds like, which we can deal with that later. But the audio is important. The only thing that's said by the bystander is he says something to the effect of, "I think he just got tased."
Hey, so this is what they do.
I'm sorry?
Yeah, and he indicates that Mr. Ellis is what they do.
Well, he is. He's naked. And he says, "I think he just got tased," and says something to the effect of, "Just another day in Tacoma," or something. But there's nothing, I mean, that's not being offered for the truth of the matter asserted. It's merely just some commentary.
The Chamber of Commerce may not want to hear this, but maybe, but maybe that's a present sense impression. Anyway,
I mean, I don't see how it's prejudicial at all. It's just there's nothing that he says that would be derogatory towards Mr. Ellis or in general.
is it concern about what the bystander says?
Yeah, sure. I think the bystander's commentary shouldn't be listed. And also don't see how the audio of Mr. Ellis, although he may be identified as a person that is in the video, his voice hasn't been identified, anything of that nature. The voice on the video has not been identified. Mr. Ellis's voice hasn't been identified. And how he sounded that night wouldn't be relevant to how he sounded on March 3rd of 2020.
We can say the same thing about the 2020 videos. No one, I mean, they had witnesses testifying about what Mr. Ellis was saying in there, but it's absolutely relevant. Mr. Ellis is, when you hear Mr. Ellis in the 2019 incident, he's on the ground and there's no one around him, and he's making some of the exact same noises, these like distressed sounds from him that you hear in the 2020 incident, despite no one being around him, anything like that. And you can hear him kind of like having these distressed noises. And so in 2020, the state wants to insinuate that that's because of what these officers are doing to him. But in 2019, no one's around him. He's making the same type of noises. So that's why it's particularly relevant. That's why the state doesn't want it in. So it's either about Mr. Ellis or it's about what the bystander is saying. So
Well, the court asked me to address both, so I addressed both.
I did.
I would note that Ms. Mixon was going to identify Mr. Ellis's voice on the video, and there was objection to it as far as the 2020 video was concerned. In addition to that, there was corroborating evidence of it being Mr. Ellis based on the defendant's statements.
Right, well, if the video comes in, I'm not gonna edit out the sound.
The other issue, Your Honor, the state would like to bring up is with the two deputies that they intend to call, there are statements of Mr. Ellis that are included, particularly with Deputy Bull, and the state would object to those statements coming in as being hearsay. There's no other reason to admit them other than for the truth of the matter asserted. One of those statements was after he was placed in custody, prior to him being Mirandized. The other group of statements was post-Miranda, but it was also after the head injury, in which Mr. Ellis is going in and out of consciousness during the contact with the deputy.
I don't know what the statements are, so.
The statements would be post-Miranda, what happened this evening, or he was asked if he remembered what happened this evening. He said, I don't remember. The deputy reminded him that he was at A&W. He said, I got in a fight and I woke up here. And then I tried to ask him further questions about the events of the evening, but he was in and out of consciousness. The pre-Miranda statement was he asked for his name and if he was on any type of drug, and he responded with meth and weed.
So I didn't say,
And if he was on any type of drug, and he responded with meth and weed.
Yeah.
Both, that was in response to a question. He was in custody and pre-Miranda.
any comment? Are you gonna go into the statements by Mr. Ellis to the Pierce County Sheriff's officers?
well, I don't think it's hearsay. I think it's a statement that's made to the deputy in furtherance of his investigation and goes to the effect of why he's acting the way he is. I mean,
Because it's true, right?
well, I mean,
Isn't that the argument?
I think it goes beyond. I mean, you could say it's an excited utterance in that moment. It's a statement against interest. I mean, I think there are a number of if it's being offered for the truth of the matter asserted, I think there are a number of hearsay exceptions that apply as well, right? Which is in this context, why would he make such a statement to deputies if it wasn't true? So I think that in this context, it's meets one of the exceptions to the hearsay rules.
What about the got a fight in the A&W
I don't.
or the restaurant or wherever it was?
That's not particularly useful in this scenario. I mean, again, I think it's a statement against interest. It's Mr. Ellis describing in that moment what's
So
going
is this a
on.
statement against penal interest?
I'm sorry, Your Honor.
Is this a statement against penal interest?
One could argue that, except for the fact that we have an individual, I mean, the only way we get there is, he's in custody at the time, and he hasn't been Mirandized on the prior statement. And I think that the against interest doesn't turn around and mean that it's admissible because it's against his interest. The other aspect of it, Your Honor, you have somebody that is suffering from a head injury, and I would find that hard pressed for this court to allow those statements in if it were Mr. Ellis actually on trial, in the sense of going in and out of consciousness when the deputy recognizes that.
Sure. But this isn't that proceeding. Last week, you guys argued that the statement made about him relapsing was a statement against penal interest.
And the court said, I'm not sure about that.
That's right. But this is clearly a little more different, isn't it? Still not sure about it, but I mean, here he's actually talking to a police officer. And here he could conceivably be tested for it, whereas a statement having relapsed in the past is far less specific and not made to a police officer. Therefore more problematic about whether or not it's a matter of penal interest or not. And with respect to Miranda, the whole idea of Miranda is to essentially test the voluntariness of a particular statement. And so if someone is in custody, we assume that their statement may be made under some kind of duress unless Miranda's been given and understood. And of course, if somebody is going in and out of consciousness, I suppose there's an issue, or at least conceivably, there's an issue that someone didn't understand all of that because of their wounds or their medical condition. And that would very possibly be the case in a particular situation. But here we're not talking about Mr. Ellis's liberty being at stake. And we are talking about whether or not the statement is voluntary and therefore reliable. Well, I'll think about that, but I sort of am leaning to the idea that it is a declaration against interest.
Your Honor, there's a few other issues with the deputies that they intend to call. Defense interviewed them, the state wasn't present, but we did receive Mr. Bones' summary of those two witness interviews by defense. And in those summaries, there's comments about how similar this incident, the 2019 incident, is to the 2020 incident.
This is by whom?
The two deputies, Bull and Hood.
Oh,
The similarities between the two, and there's also comments regarding, oh, this could be us, as in, like, they could be sitting as defendants.
right.
And it's the state's position that their opinions on those issues, one, invade the province of the jury, two, aren't relevant and are improper to be testified to, and would ask to exclude anything of that nature.
Defense disagree?
No, Your Honor.
Okay, I agree with you. They should, because they shouldn't venture into the opinions of the officers, the Pierce County Sheriff's officers, about how it's similar to the events of the March 2020 incident. Anything else?
All I have as far as those issues I would go. Mr. Lewis, is there anything else?
Yes, Your Honor, one final issue, or one additional issue. The defense intends on calling Deputy Prosecutor Greg Greer to talk about conditions of release. Mr. Greer prepared the affidavit of probable cause for the robbery second charges. That should not be relevant in this case. I don't believe the
You mean the declaration itself?
declaration itself or his preparation of it. I believe Mr. Greer is going to be asked to talk about conditions of release. However, I would note that Mr. Greer did not do the agreement, handle the agreement, has no personal knowledge of Mr. Ellis' condition of release. So,
Not anything more than any of us could look at when we see the order and release conditions.
sir, but I'm concerned if they were planning on going into the affidavit of probable cause, that's not
I don't know.
an issue.
Where are we going with Mr. Greer?
Morning, Judge.
Good morning.
I intend to ask him about the declaration of probable cause. I intend to ask him whether he filed charges. The charges were pending, that he was arraigned, that there were conditions of release. Those were modified on October 21st. to release to treatment, and that he was not to use or possess non-prescribed mood-altering drugs.
Did that appear in the amended release conditions?
It does, Judge.
And was that something Mr. Greer agreed to?
Yes, actually, I.
His
also-
signature on the document?
No, I think it's Tyler Kennedy was standing in for whoever was, I think Pat Hammond was one of them. There's multiple prosecutors assigned at the time. So I have a
Right.
court-certified conditions of release. If they just want to admit the documents, we can admit the documents, but I didn't think that would be their preference, so.
Well, that may be their preference, but in lieu of Mr. Greer testifying whatsoever, I mean?
Well, I think not in lieu of testimony altogether, because the court has indicated that the 2019 incident is relevant under 404B for motive, opportunity, intent. He's released on conditions of release on a serious felony charge.
Right.
And violation of those conditions would result in him being taken back into custody. And so certainly I intend to offer through Mr. Greer that he charged him with a serious offense, that he was released on conditions by agreement by the state that incorporate treatment components through pretrial services, and that conditions of release, if violated, result in the state seeking to modify and take him back into custody. I think all fair game and all relevant to the 2019 incident. Thank you, Judge.
My understanding is that Mr. Greer's involvement was the filing of the charges, the preparation of the declaration, and that's all. Other DPAs were signed to Mr. Ellis's case. I don't know that Mr. Greer has any personal knowledge regarding what occurred after the charges. And
Absolutely, as I talked to him yesterday. He knows exactly what the conditions of release were, that they agreed to PR him so that he could engage in treatment, that it was through pretrial services. That
Was it still Mr. Greer's case at that point?
I don't know whose case it was assigned to. It probably was assigned to nobody, Judge, because it was only, 3 months old at the time, so I assume it's with a negotiator until negotiations fail. At least
Right.
that's how they were doing it at the time, I think.
Yeah, that's probably how they're
Because-
still doing it, but I guess the thing would be is, so if counsel wanted to talk to somebody who had authority to change the release conditions in the prosecuting attorney's office, you would have called the person who was the author of the declaration for determination of probable cause? In this case, Mr. Greer? And you're saying that's what happened?
Well, Mr. Greer charged it, wrote the declaration of probable cause.
Right.
I assume, and I shouldn't say, I assume, I talked to him. He was aware of what the proceedings were, when the proceedings were, and that there was an agreement. Tyler Kennedy is a very new DPA relative to Mr. Greer, who appeared, Judge knows how Mr. Greer works, he doesn't show up to half his hearings, he sends people to do it. And so I assume that was the process. Either way, Mr. Greer was aware of it, agreed to, or at least was aware that they were agreeing to personal recognizance release so that he could comply with the treatment being requested by Ms. Sontag, who was his attorney at the
All
time.
right, well, if he's got personal knowledge of this, he can testify to it. If it's all just stuff he read in the file that any of us could have read, well, that's different, isn't it?
and I would ask the court for an offer of proof once Mr. Greer is here.
Well, when he's here, you can ask him yourself, Mr. Lou.
Thank you.
Well, when we take the break, I'll get Mr. Greer on the phone. Mr. Lou and I can talk with him, and he can answer whatever questions he wants.
So you can get him on the phone.
5 minutes ago, he gave me a thumbs up, so.
Great. All right. Isn't he about due to retire?
He starts a murder case tomorrow, in Judge Murphy's court, and then he will retire.
Okay. So I guess we'll see. Anything else before we have the jury?
One thing, Your Honor, the juror issue, apparently it's not an issue, but I don't believe ignorance is necessarily bliss, and I think for purposes of future potentials, if the court has any information as to what that particular juror was concerned about, I'd at least like to know about it for due process reasons. That's all.
I'll think about it. And in part because I'm also worried about this idea that occasionally I think I know what's going on and I'm wrong. You know, so I could misstate something too, in trying to be as transparent as possible, but misstating things doesn't help anybody. So I could
Yeah, I
be,
disagree with that, Your Honor. I don't know what you know. I guess that's
Yeah, and I guess what I'm telling you is I don't even know what I know.
Okay.
All right, so we're about at the point of hearing from Mr. Arbenz, right?
Yes, Your Honor, I don't know if you could maybe take a quick bathroom break here, because I'll probably go an hour, and
I don't dare do anything else evidently.
I can be back in 2 minutes, but.
All right, we'll take a brief recess for that.
Judges said the court's aware, I did speak to Mr. Greer about what to call the charges.
Yeah,
I told him I would confer with the court. I am proposing serious felony. So it doesn't want to do that, let me know what to do with him so he doesn't run afoul of the court's.
well, I thought the deal was, you were gonna simply use the charge. I mean, there was never a deal as such between you guys. I urged you all to reach one, but it never got reached. So now what I've got is, attempted robbery in the second degree, right?
Well, he's charged with robbery in the second degree.
Not attempted robbery.
No.
Well, it's robbery, then there's usually a deal of describing an attempt. So,
Well, Mr. Greer,
charged with robbery.
he charged him with robbery, but in the declaration of probable cause indicated he was charging him with attempted robbery.
Okay. All right.
All please rise.
Welcome back, everybody. Please be seated. Well, I hope everybody had a restful weekend. I note the local football teams did nothing to alleviate our anxiety, except to the extent of winning in the end, after a lot of anxiety. In any event, now that we're back, ladies and gentlemen, please give your attention to the opening statement of Mr. Casey Arbenz on behalf of the defendant Matthew Joseph Collins. Mr. Arbenz.
Thank you, Your Honor. Morning, everybody. I know this case has been going on for quite a while. The defense case is starting today, and we are going to try to move things along and try to get you out of here. We do appreciate your service. On my first day of law school, I'll never forget the first thing the professor said. When you're in a trial, if you have the facts, if the facts are on your side, pound the facts. If you have the law's on your side, pound the law. And if you have neither, pound the table. Now, our case, the defense case, Officer Collins' case, is just the facts. I'm here today to tell you what the facts are and why those facts will lead to a not guilty verdict. But Mr. Osserer, in closing arguments, will tell you about the law, all right? Now, the extent to which the state's case is just pounding the table, I'll let you decide. Or maybe it's pounding a square peg into a round hole. Not bringing in certain witnesses, picking and choosing, hiring the out-of-state police brutality team to come on in at top dollar to try to prove a serious crime. But the facts are there, and I tend to pound the facts. Now, one of the places we have to start in evaluating this case is with Mr. Ellis. Now, I was taught not to speak ill of the dead, and I have no intention to badmouth somebody who's no longer with us. We talked about in jury selection how horrible it is to have a loved one, a family member who's got a problem with drug addiction. But this is a murder case and a manslaughter case, and my client has been charged with both of those things. And we know that Mr. Ellis was high on methamphetamine on March 3rd. We know he had 2,400 nanograms per milliliter in his blood. And the degree to which that affected his behavior is highly relevant in understanding who he was on that night and what these officers were faced with on March 3rd of 2020. And oftentimes in a case like this, you don't really know. You don't know how drugs might affect somebody. In this case, we do. And so we're going to start with Mr. Ellis. We know that he started using drugs when he was around 20, so he had about 13 years of meth addiction. And we know that in 2015, he had a violent encounter with police. And the defense is going to raise that, again, not to disparage Mr. Ellis, but to see what police officers who dealt with Mr. Ellis when he was under the influence of methamphetamine had to deal with. And in 2015, he was accused of a crime, and the police responded. Now, in that case, interestingly, Mr. Ellis was compliant initially in his contact with the police. They put him in handcuffs, and he said, hey, I've got a bad shoulder. Would you mind putting me in 2 sets of handcuffs? And because he'd been compliant up to that point, the officers agreed. They put him in 2 sets of handcuffs, gave him a little extra room. But that was a ruse, because once he was in the back of the police car, officers noticed that he started reaching into his pockets. He had 2 sets of handcuffs, he had extra room, and the officers noticed that he had a needle, a drug needle, an intravenous drug needle, filled with methamphetamine in his pocket. And they said, knock it off. Quit reaching for your pocket. He refused. He had to be taken out of the car, and then the fight was on. And eerily similar to the incident in 2020, Mr. Ellis had no quit in him. 3 officers had to hold him down to try to get the needle out of his pocket, try to get him in regular cuffs. They had to tase him twice. They had to hobble him. He was kicking and bucking and biting and banging his head on the gravel, getting scars on his cheeks, and 3 officers had to hold him down. They had to hobble him because he was kicking and bucking and wiggling, trying to move and get away. He had no quit in him, ladies and gentlemen. A few years later, in 2019, you heard about the incident at the A&W. I won't get into the specifics of what happened, except to say that he was eventually running naked down the street, and the police had to try to take him into custody. And you'll see the video of that incident. A passerby was able to capture that. And you'll see how Mr. Ellis responds to police when he's high on methamphetamine. At one point, the officers have him down, and he's being minimally compliant on the ground, but he's still looking up. He's making a lot of noises that you'll hear are very consistent with what we have in 2020. And then abruptly, he charges at the officers. He ran towards them. He didn't try to flee. He ran towards the officers, had no quit in him. They had to tase him. And he immediately jumped up again, and they had to tase him a second time. And then it was the same thing, the struggle, trying to get him in handcuffs, trying to get him restrained. They tried to call for aid. He was resistant to aid. He said, leave me the fuck alone. Nobody touch me. He didn't want anybody to even help him. So we know how drugs affect Mr. Ellis based on those 2 incidents. So as you'll see, Mr. Ellis was charged with a crime, robbery, attempted robbery, for that 2019 incident. And he went to court, he pled not guilty, and he was assigned what we call conditions of release by the judge. The judge said, Mr. Ellis, I'll let you out, but one of the things you have to do is go into treatment. Another thing you have to do is you cannot use drugs while you're out. You can't use drugs. So, for a period of time, he's doing well, right? He's getting sober, he's going to church, he's playing the drums, doing good things. He's also going to treatment. And in his treatment, he was having a counseling session with one of his treatment providers, and he was asked about the 2019 incident, about what happened, what got you to that state where you tried to rob the A&W, you took off your clothes, you tried to fight the police officers. What got you to that point? And Mr. Ellis said, I was in a state of meth-induced psychosis. Those are his own words during a treatment session. So he knew how methamphetamine could affect him. And he had all the reason in the world to stay clean. And he was, right? He was staying clean, he was playing the drums, he was going to church. You heard about March 3rd. He was doing well. You heard that he had a conversation with his mom. He talked about coronavirus. He said, Mom, what's going on with this coronavirus? This is crazy. So he was doing well. And then we don't know what happened, right? We know about Mendel Everson and how he and Manny Ellis both left that night and never returned. And we also heard that there was bad meth on the street during that time. So that's Officer Collins. You know him, you've seen him, you've been watching him in court. I'll tell you, Officer Collins, my client, Mr. Officer's client, is excited to talk to you. He's expressed to me a number of times how frustrating it is to be on trial and have to listen to your dumb lawyers talk the whole time, instead of being able to get up and tell the jury what happened, why you did what you did. So he's excited to talk to you, but I'm going to tell you a little bit about him until he has a chance to take the stand. Officer Collins is married. His wife's been present. Her name's Lisa. She's been present a number of times throughout this trial. They've got 4 kids, a 12-year-old, a 10-year-old, a 6-year-old, and a 3-year-old. His parents have been here throughout the trial supporting him. His dad was military, his career military, and so Matt grew up as in the Army. I think we call them Army brats. He was, going from base to base, and never spent more than a few years in any one location as a kid. One of his hobbies was wrestling. He was a wrestler in high school, called a grappler. He would eventually be a coach on his Army wrestling team when they weren't deployed. He had about 20 years of grappling and wrestling experience before this incident in 2020. He went to college after high school. He graduated with a degree in history. I hesitate slightly to tell you. In every case, you've got good facts and bad facts. Good fact is that he went to college here in the Northwest. Bad fact is he went to the University of Oregon. So I would ask you not hold that against him. I noticed the shirts you all wore. But he graduated with a degree in history from the University of Oregon. And then he decided to serve his country. And he enlisted in the United States Army. And he had an option of going to OCS and pursuing being an officer. Decided that he wanted to serve and earn the respect of the higher-ups before he became one. And so for 8 years as an Army Ranger, Officer Collins served his country. Multiple deployments to Iraq and Afghanistan. He served our country. Eventually, the stress of the deployments, he got married to Lisa. They'd had their first child. She was pregnant with their second child. The stresses of the routine deployments started to wear on him and his family, causing stress in the family, and so he decided to retire from his military service, and he was honorably discharged from the U.S. Army as a Ranger after 8 years. Officer Collins wanted to keep serving his community, and so he went to the police academy in Tacoma, and he was elected president of his class by his colleagues. He was top of his class at the police academy. He's been a police officer up until this incident for 5 years, not a single blemish on his record. He, along with his partner, Officer Burbank, won the Medal of Merit as police officers for Tacoma PD. They responded to a situation where a clerk at a at a convenience store had been assaulted. And when they arrived and were taking the statement of the convenience store retail clerk, the assailant returned with a 15-inch butcher knife, screaming, "Kill me, kill me!" And Officers Burbank and Collins did not kill him, but they were able to safely de-escalate the situation and take that person into custody. And for that, they won the Medal of Merit, given to them by the mayor of Tacoma. Officer Collins has 8 commendations along with that Medal of Merit. Now, you've all seen this slide. This is a view of 96 and Ainsworth, South Tacoma, an aerial view. And we've all heard, we talked about it in jury selection, that this area of Tacoma is a rougher part of town. And there are drugs and gangs and murders and rapes and all of that. But it's also a residential area. And there are homes here. That's really all there are in that main area. And, with homes come families and there's kids. And there needs to be police. And Officer Collins and Burbank and Rankin are the guys that patrol this rough neighborhood to protect these people. They work the graveyard shift in probably the roughest part of town, one of the roughest parts of our state. And you're going to hear from our witnesses who are going to tell you how tough of a job it is. I know you already know that, but their job is to protect these folks. And that's the picture, a little bit zoomed in on 96 and Ainsworth. And I know you've seen that. But just looking at that picture, I'd like you to notice the nature of that intersection. It hasn't really come up too much, but there's a driveway there. And as you know, a lot of the action in this case takes place in the middle of the road. And you probably know how dangerous that is for police officers and for Mr. Ellis and others to be out in the middle of the road at night when people are driving, maybe people are drinking and driving, when they could be turning into the intersection, or maybe even turning into that driveway. So on March 3rd, 2020, and I won't go up and show too closely, I think we're all pretty aware of what was going on. But as you know, our incidents here, the officers are facing west on 96th. But before that, Officers Collins and Burbank had made a stop of a person who had a headlight out. And they did their CAD search, and that person, the owner of the vehicle, was African American and had warrants for his arrest. And Officer Collins and Officer Burbank approached the vehicle, gave a warning for the headlight, said clear up the warrants, and let him go. Officer Rankin and Ford backed them up on that call. And it was a quick call. They decided to let the folks go, and they left the scene. Now, as you know, Collins and Burbank went west on 96th, and Ford and Rankin went a different direction. And Officer Collins and Officer Burbank were at the intersection when they actually cleared the scene from the stop there on, I believe it was A Street, where they'd stopped Mr. Bogan's vehicle. And that's important in the timeline. And that was actually what they were taught to do, is you don't clear the scene while you're at the scene, because you're exposed. The person you just stopped could come attack you. You actually drive away and then clear the scene, and that's what they were doing there at 96 and Ainsworth. And as they're sitting there at the stoplight, they see an individual, Mr. Ellis, out in the road. He's out in the middle of the road, in a dangerous area, kind of in this region here. And a car is trying to make a left-hand turn. And this isn't something that they're focused in on. It's something they catch out of the corner of their eye. But they essentially see a person trying to touch the passenger side door handle of this vehicle. Now, it could have been anything, right? It could have been totally innocent. He could have just been dropped off. A little odd to be dropped off in the middle of an intersection. Could have been a family member, a friend, somebody who's trying to flag down. But the nature of the fact that he was trying to open the door handle and the fact that the car drove off in that manner raised some suspicion. Now, Officers Burbank and Collins will tell you that Mr. Ellis had a bag in his hands, carrying something at that time. And so they say, hey man, what are you doing? What are you doing? Officer Collins yells to him from the driver's side, what are you doing out there in the middle of the road? And they weren't necessarily expecting it, but this individual, Mr. Ellis, runs over quickly and gets strangely close to Officer Collins' window. He says, hey, something along the lines of, I'm having a bad night, I've got warrants, I need help. And so Officer Collins says, okay, hey man, it's all good. Why don't you just go over there, sit on the sidewalk, get out of the road so you don't get hit by a car, and we'll talk to you. Officers had no expectation of what was going to happen. It's nothing different than the stop they had just made only about 90 seconds before. And as Mr. Ellis is walking around the police car, Officer Collins grabs his microphone and is about to call it in. Just a routine stop. Hey, we've got an individual, says he's got warrants, needs our help. We're going to talk to him. Before he can do that, he notices that Mr. Ellis has fixated on his partner. He's eyeballing him. He's giving him a look that suggests that there's going to be some kind of interaction, some kind of unfortunate scene. And immediately, Mr. Ellis says something along the lines of, or maybe I'll just punch you in the fucking face. And so as Officer Burbank is rolling his window down, suddenly he's rolling it back up because of the nature of Mr. Ellis's aggression towards him. Officer Collins, being the good partner he is, jumps out of his car, runs around to the front of the police car, and then Ellis turns around, grabs him, throws him. Now, Officer Collins is a big guy. At that time, he weighed 215 pounds. He weighed 235 pounds with all of his gear on. And you saw the pictures, and they're not major scrapes on both elbows, but he was also wearing thick, long-sleeve police uniform. But that's where he got those scrapes, from when Mr. Ellis lifted him and threw him back, and he fell back on his elbows. And then, as you've seen, the fight was on. Now, we have, obviously, video of portions of this incident, but we have this fight that goes on. And what both officers Collins and Burbank take away from the incident is that Mr. Ellis has no quit in him. He will not put his hands behind his back. They tase him 3 times. As you've seen, after one of the tasings, Mr. Ellis actually says, "Do it again," right? He gets punched multiple times. You've seen the video where he's getting punched by my client, getting the elbow strikes, and then there's a gap in the video, and then 10 seconds later, in the Seth Cowden video, they've moved positions. And imagine that. Officer Collins, a 235-pound officer, is on top of a guy delivering elbow strikes. And then 10 seconds later, he's now behind Mr. Ellis, who's standing. The state mocks this superhuman strength. But how do you get a 19-year-old or 19-year grappler, how do you get out of that position and get behind him?
Argumentative.
These are just the facts, Your Honor.
Sounds like a bit of an argument. Go ahead.
You've seen the video that Mr. Ellis gets behind Officer Collins. So we know that punching him doesn't work, tasing him doesn't work, the attempted LVNR doesn't work. We hear the grunting and noises that Mr. Ellis is making. Eventually there's kicking. Eventually there's hobbling, kicking, and then even spitting. And all the while the officer's saying, "Put your hands behind your back. Put your hands behind your back." That was the intent, was to get him into custody, because as you know, as you learned from Lieutenant Wilson, the paramedics will not help somebody until the scene is safe and the individual is under control. And Mr. Ellis had no intention of becoming under control. Our use of force expert will tell you how dangerous a fight like that is for police officers. He'll tell you that these guys have guns on their hips. As you heard in the testimony, there are live live rounds in the chambers. And if a gun gets loose, we know that the magazine, Officer Burbank's magazine, came loose during the struggle. If a gun gets loose, somebody is going to get killed. We know you'll hear about needles in people's pockets and the concern that police have that somebody, when they're trying to take them into custody, will have something, a dangerous weapon or a needle or something in their pockets. You can imagine being in the lane of traffic, how dangerous that is to be in an unsecured fight with somebody. And you're going to hear all the evidence about what a dangerous situation this had become due to Mr. Ellis simply not putting his hands behind his back and going into custody. You'll recall the testimony of Mr. Ellis's fight. There was the expert the state called, I can't remember his name, who talked about how after the police got Mr. Ellis into handcuffs, that he still moved 7.5 feet. This was someone who, when he didn't have cuffs on, they had to tase him, punch him, and try to LVNR him. When they got cuffs on him, he was kicking and thrusting and bucking. When they got him hobbled, he was still kicking and wiggling. And then they had to connect the hobbles to the handcuffs simply to get him restrained. And then he started spitting. There was no quit in him. And then he started bashing his face on the ground, thrashing. Now, in the timeline of events, we know that officers Collins and Burbank fought with Mr. Ellis for 3 to 4 minutes, which anybody who's ever been in a fight can tell you, or if you ever watched boxing or any MMA sport, 3 to 4 minutes is a long time to be in a knockdown, drag-out brawl. Officers Rankin and Ford show up at 23, 24, 19, and they're only there for about 25 seconds before Sergeant Lim arrives. And it was around that time with Lim, Messinio, and Sanders that they were able to get Mr. Ellis in hobbles and fully restrained. And it was about that time that officers Collins and Burbank, as they call it, were smoked, and meaning they were just absolutely out of energy and out of they were had lactic acid building up in their arms, and they needed a break. So their boss, Sergeant Lim, told them to go up towards the front of the police car, go get a breath, catch a breather. So that's also the time when Sergeant Lim arrived that aid was called. They called for fire, as the police put it. So at 23, 24, 14, or 44, give or take, paramedics are on their way. And we know that at that time, within 30 seconds or so, that Officers Collins and Burbank are out of the scene. That Mr. Ellis is not only alive, but he's going to be alive for at least 10 more minutes. And they're off the case. The only real involvement that they had was when paramedics arrived, Officer Collins went and said, hey, this guy might have excited delirium. Might look out for that. Now, we've heard from Ayanna Malang, or Ayanna White. For a couple years we've been reading reports of Ms. White, but her name is now Malang. And she gave you some really important testimony about the timeline of events. She talked about how it was after 11 at night. She finally got her kids to bed, things were settling down. Any parent here can understand what it's like to finally get to a situation where you can lay down in your bed after a long day. And so she lays down in her bed, and she starts to hear a commotion outside. Now, she lives on 96 in Ainsworth, so it's not totally unique to have a commotion or some kind of disturbance outside. But like probably all of us would do, is for 30 to 60 seconds, she told you, she laid there hoping that whatever it was would go away and she could go to sleep. Finally, after 30 to 60 seconds, she decided to get up and look out the window and see what was going on. And she described another 30 to 60 seconds of watching a fight out in front of the police car. She described it as one officer fighting Mr. Ellis. And then she talked about waking up her husband, and that being another 15 or so seconds. So, it's always hard with time to know exactly how long, but for about 2 minutes, she witnesses, in sum, the struggle and the fight and the commotion that was going on between Mr. Ellis and the police. Now, Ms. Malang's testimony is completely consistent with what you heard in the recordings of the officers in terms of the timeline. She also has no connection to James' Bible, and her cell phone never miraculously self-combusted. And it was 2 minutes before she heard, and she was very specific about this, she heard Ms. McDowell yelling. She heard the, hey, leave him alone, right? She's very clear about that. So that 2 minute period of commotion was broken when she finally heard Ms. McDowell yelling. Now, as I mentioned, officers gave statements. Officers have Fifth Amendment rights. They did not have to give a statement. They know, as police officers, when you give a statement, the risk is, if the evidence comes out and it's inconsistent with your statement, that you're now locked in and you're going to look to be untruthful if somebody contradicts your statement.
Overruled. You may continue.
But they voluntarily gave statements. And ladies and gentlemen, there is nothing in the video evidence that's inconsistent with those statements that these officers gave voluntarily. In fact, Mr. Officer walked through with Officer Collins and his statement, the video, and how play by play he described his interactions with Mr. Ellis. They did it only a few days after, when they knew, as you would expect, police officers would know, that there would be doorbell cameras and Arlo cameras and passersby with cell phones recording the incident. And there is no video evidence that contradicts their version of what happened. Now, the state will tell you that the officers never said anything about how Mr. Ellis said, I can't breathe. And they said, well, we couldn't hear anything because we're in a fight, and Officer Collins will explain that to you. You also notice that in his statement, there is no comment about Mr. Ellis saying, do it again, right? Which you'd think would be something that you might say when you're explaining how a person has superhuman strength, who fought you, who's being aggressive. Officer Collins will tell you, I never heard that either, because I was in a fight. I was in a serious knockdown, dragged out brawl with a person who had nothing to lose and no fight in him. Now, the state relies heavily on Sarah McDowell and Seth Cowden and Mr. Lowry. Now, the most significant factor amongst those three witnesses is that none of them saw Mr. Ellis with anything in his hands. And we know that the evidence suggests that he had the bottle of water. Remember, Mr. Liu in his opening grabbed the bottle of water, right? We know that he went with his EBT card to 7-Eleven and bought water and donuts. The state never showed you these pictures. The state didn't want you to see it. They wanted you to see a lot of pictures of Mr. Ellis's body. They didn't want to show you the water or the
Objection,
donuts.
argument.
Continue.
But those witnesses, Cowden, McDowell, and Lowry, said he didn't have anything in his hands, and they were very clear about that. Second reason you'll question Ms. McDowell's testimony, if you watch the video, it's the Vivint video, you see her vehicle behind the police vehicle, and you'll hear a little beep. We tried to bring this out in testimony. You hear her honk, and then you'll actually see her put her car in reverse to back up as if she's going to drive around the police vehicle. And it's right about that time that she starts recording and starts yelling. But she was going to drive around the car. She didn't see the whole interchange. She didn't see Mr. Ellis walking down the street, listening to music, observing nature as the state tries to portray this. She didn't see that.
Objection, argument.
I'll allow that, overruled.
She didn't see that. She was actually honking and then backing up so she could go around the police vehicle. And then we've all seen this from Ms. McDowell. Wait till I'm in the stands. I'm lying to shut you all down. This witness, her testimony and her timeline is totally inconsistent with Iona Mullane. It's totally inconsistent with the officer's statements, and it's totally inconsistent
Objection,
with
argument.
logic. When you look at the facts, you see a person, Mr. Ellis, who had methamphetamine in his system, and not only at a lethal rate, but a toxic rate. The suggestion that he was just walking down the street, listening to music, observing nature on 96 and Ainsworth, and that these cops just decided to jump out of their cars and start wailing on him,
Objection, argument.
versus the suggestion that being that high on meth, he was out in the middle of the street causing a disturbance, and that because he was on conditions of release and not to be using methamphetamine, he decided to attack the police. Use your common sense, folks, in evaluating the evidence in this case. What's more likely? A decorated officer?
Objection. Argument.
I'll move on here. Thank you. Now, if the officers wanted to jump somebody, would they do it under 2 streetlights? Would their car be parked at the intersection and they would leave the engine running and decide to just jump out and start beating on somebody?
Objection, argument, Your Honor.
Overruled.
Or would they follow him down an alley? Officer Burbank, in his statement, talked about having a baton in the car. You're going to beat up on somebody when you grab the baton? When you pull over to the side, at least? You see these pictures? State didn't want to show them. You see the smudging there on the left side of the door frame. You see the powdered sugar there on the window. You see it there from a different angle, slightly. It's small, doesn't show up in every angle. You can see it right there. You see a close-up of the powdered sugar, which is totally consistent with a scenario where someone who's eating donuts or carrying a box of donuts starts punching the window of your vehicle, and the state doesn't show you this. And it's totally consistent with the statement the officers gave 3 to 6 days after the incident. And those smudge marks, the reason it's smudged is really significant, because it shows that after they got in the fight with Mr. Ellis and went back to their cars and were hot, and they didn't know he was going to die because they never wanted to hurt him, and they didn't know that this evidence was even on the window, they rolled the windows down because they were hot and they needed some fresh air. They didn't even know it mattered. And now here we are, and it really matters because it shows their version is accurate. So this is a murder and manslaughter case, and so the manner of death is important. And I'm not going to get into the law, but the state does have to prove that these officers killed Mr. Ellis. And that's why Dr. Clark's testimony has been so significant. And that's why his initial report is so significant. Dr. Clark testified that there were no anatomical findings in this death. Mr. Ellis didn't have any anatomical signs to lead to a conclusion as to how he died. And he said the meth concentration is well within the fatal range and could have caused Mr. Ellis's death immediately. He said the placement of the spit mask is a significant factor and possibly the most important factor. And as you know, none of these officers had anything to do with the spit mask. He stated, "It is unlikely this death would have occurred due to the physical restraint alone without the contributing conditions of meth intoxication and a dilated heart." He said, furthermore, an argument could be made that the extremely high methamphetamine concentration should be considered the primary factor. We're going to call experts. We're only going to try to call a few. But our experts are going to keep it straightforward and simple. They're actually going to dispute the notion that there aren't anatomical findings because there are two obvious ones. 2,400 nanograms per milliliter of meth in Mr. Ellis's system, bad meth, potentially. Meth for somebody who had been clean and sober for 3 months, thereby lowering how much tolerance he had. 2,400 nanograms. That is an anatomical finding in his blood, in his toxicology report. They're also going to say that he had an enlarged heart, and that his heart could not handle the demand that was put on it after this fight with police where he had no quit in him. Our experts are going to rely on the fact that Mr. Ellis had a pulse for 4 minutes before Lieutenant Wilson started doing CPR. I'm sure you're tired of testimony regarding PEA, pulseless electrical activity, but our experts will just focus on the fact that Lieutenant Wilson wasn't just sitting there twiddling his thumbs for 4 minutes while Mr. Ellis didn't have a pulse, but actually commenced CPR at that moment. Our experts will say that the heart rhythm they see is not consistent with hypoxia. And lastly, we'll call a use of force expert who's actually from Washington and who, unlike Jack Ryan, will tell you a little bit about what it's like to work the graveyard shift on 96 in Ainsworth. They'll tell you that you have to look at a person's prior actions with police when they're high on drugs to understand the full picture. Our experts, ladies and gentlemen, will rely on the facts. They will ask you to apply common sense in how we will ask you to apply common sense in how you evaluate those facts. And lastly, we're going to ask that you evaluate Officer Collins. You take into account his 13 years of service to our country and to our city. And in just the way he's fought for you, we ask that you fight for him. Thank you.
Okay, well, I know the jury hasn't been out here that long, but the rest of us may need our federally mandated 15 minutes rest break. So we're taking a morning recess this time. Please not discuss the case among yourself or anyone else. Thank you very much. Word break. It's true, they didn't object. So you're saying I shouldn't say it? You opposed to this? Mr. Arbenz is pointing out that the state didn't object.
Right.
But otherwise says, but I don't really care. Is that what you said? I assume he really does care, but he's just saying he doesn't care.
I did carry on. He didn't object, so I should say.
All right.
Your Honor, I don't think that, I mean, it always puts the state
I'll,
in
I'll,
there.
I'll point it out to him.
Thank you.
Let's have the jury. Who's the first witness going to be? And are they here?
Byron Jones.
Okay.
Your Honor, can we just have a minute? They told us a different witness was first, so we,
Oh, okay.
Byron Jones, then Wolf, then Bull.
very different. All right.
I will have to stop us promptly at noon because I have a meeting that I'm supposed to attend. Let me know when you're ready.
Chance to make sure all your exhibits are ready and you have everything.
What's this order gonna be this afternoon?
You were finished Wolf, then Bull, then Greer, then Wanda.
So is Mr. Jones being called by Defendant Rankine? Okay. Thanks.
And Paul,
Oh, and Paul, sorry.
is he gonna be after Father?
He'll be before.
Okay, so I just wanna make sure we have the order right. After Greer is gonna be Paul? We have them assigned out, so it's all.
We can do Paul, then Greer, then Wanda.
I did warn you guys about staying organized on this.
We've got a plan, Judge.
Right, but you need to share it, you need to share it with the rest of us, including the state.
Yeah, and actually earlier this morning, they told us it was gonna be in the order that they sent it to us. And
Well-
we started with Bull, and then Byron, and then Bull, and the others. So we just need to understand who's coming in what order, obviously.
All right, well, hopefully you guys can straighten out between now and 1:30. I'm assuming that Mr. Jones and maybe one other person at most between now and noon. Okay, let's have the jury.
I'll find it. It's fine.
Welcome back, everyone. Please be seated. Okay, Mr. Conrad, understanding that you're calling the first witness.
Yes, Your Honor.
Proceed.
Call Byron Jones to the stand.
Okay, thank you. Mr. Jones, please come forward right about here, if you would. Right over here. And then please raise your right hand to be sworn.
We're standing up right here.
Right there is great. You solemnly swear or affirm that your testimony in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you very much, sir. Have a seat right here. Please state your name and please spell your name.
My name is Byron Jones. It's spelled B-Y-R-O-N.
Last name?
Jones, J-O-N-E-S.
Thank you. Counsel.
Thank you. Good morning, Mr. Jones. Have you ever testified in court before?
No.
Okay. Well, I want to start off with some background questions real quick and then kind of jump right into September 21st, 2019. What do you currently do for work?
Currently, right now, I'm a patrol security guard
Okay. And how long have you been that?
for about 3 years now.
Okay. And where did you work prior to that?
KFC and A&W.
The KFC and A&W. Is that the one on Pacific Avenue?
Yes.
And what was your job title?
Shift supervisor.
Okay. And how long did you have that job?
Probably say about 4 to 5 years.
4 or 5 years.
hmm
And was there a particular shift that you worked?
No.
Okay. And I want to ask you about September 21st, 2019. Remember that date?
Over the past few days, I don't know how to say it, but I've gotten myself up to speed on it. Yes, I do remember
Okay.
my statement made that day.
Is that you wrote a witness statement? Is that right?
Yes, sir.
Okay. And so, what was your job title on that day?
Shift supervisor.
Okay. What are your job responsibilities at shift?
Shift supervisor is more or less to make sure the jobs of the shift are getting done. Cash drops are being made, drawers are being swapped, and people's operational needs are being met.
Okay. And about how many employees work at the A&W? During
Anywhere
shift,
from around to 6 to 8 people.
Okay. 6 to 8 people during a shift.
hmm
Do you remember how many people were working the shift on September 21st, 2019?
No, I don't exactly.
Okay. Do you remember some of the people that you worked with?
A few.
And what were their names?
I believe one of them was Angel. Some other people probably not listed. The owner, but I don't think he was there. Operator, Jesus.
And so, tell me, did anything out of the ordinary happen on September 21st, 2019?
Yes.
Can you tell the jury what happened?
September 21st, 2019, right a little bit before closing, a gentleman entered and unbeknownst to me, I was on the back side of the line packing orders, and I heard the female employees scream saying there's a guy trying to get the money out of the drawer. I responded by coming around the counter and proceeded to help the relief manager at the time remove him from on top of the counter. After that, he proceeded towards the door where him and the relief manager proceeded to struggle, where I saw the relief manager push him out of the store and he ran away.
Okay. And can you describe what the individual looked like?
Probably my height, a little bit shorter, black male, bald, no shirt.
He had no shirt on.
Yeah, no shirt.
Did he have anything in his hands?
Not that I can remember.
Okay. And what did it appear to you that he was trying to do when you saw him?
When I first contacted him, he was attempting to climb over our counter in the front lobby.
Okay. Is that where the cash register is?
Yeah, there is a register there.
And were the police called?
Yes, there were.
And did it appear to you that the man was under the influence of any type of substance?
Objection leading.
I'll permit this, it's foundational. You may answer.
Only thing I could say that would lead me to believe that was it was extremely cold and he had no shirt on.
Okay.
And he was kind of tripping over himself.
Okay. I don't have any further questions. Thanks for coming.
Thank you. Mr. Jones, good morning.
How you doing?
So, let me just see if I got this straight. You heard something at the front counter, is that correct?
It was more or less commotion, like the lady screaming.
Okay. And the man was trying to climb over the counter?
Yeah.
Okay. Did he get over the counter?
No.
And you were able to push him back?
Yeah, we pushed him back over the counter, and when his feet hit the floor, he kind of like went back over to the door.
Okay. And then what happened?
Him and the relief manager proceeded to, in a struggle of trying to get him out of the store, because at the time of night, when closing happens, there is a door that is locked in the lobby for customers to be able to still leave in and out until we close the lobby. We were about to close the lobby when this incident happened, probably still accepting about 2 or 3 customers at this time. So there was a door unlocked and a door locked. So there looked like there was some confusion of which door was locked and which door was unlocked.
Okay. And he was pushed out the door?
Yes.
You didn't see anything in his hands?
No.
Thank you. No further questions. No questions. Thank you.
Mr. Rosser?
Just a couple of questions. Good morning, how are you?
I'm all right. How you doing?
Good, thank you. I know it was a long, sorry, I know it was a long time ago. Do you remember doing a handwritten statement for police when they responded?
Yeah.
So do you remember if you called police or did Angel call police?
I'm not sure who it was. I don't believe it was Angel. I know it wasn't me,
Okay.
but someone called the police.
Okay, and do you remember filling out a handwritten statement?
Yeah.
And do you remember writing in the statement that the man who jumped over the counter said, "Give me the money"?
Yeah, that's what everybody was yelling.
Okay. So tell me what you remember him saying specifically.
Specifically, like I said, I just relayed what the girls told me he said to them. So honestly, when my written report was written, I wrote down that he was yelling, "Give me the money," because this is what the girls said that they heard him say why they screamed. Why I responded, exactly. So yes, it might have been a little bit of hearsay or something I've heard from someone else, but this is what I was told by the females, why I responded to the front of the store.
Okay, just so I understand, you're at the back.
On the back line by the drive-through window.
Okay. And you hear the commotion from the girls?
Yes.
And they said that this individual said, "Give me the money."
Yes.
Okay, all right. And how long after the other manager was able to get this gentleman out of the front door did police respond?
I mean, while they were struggling at the door, they were already responding. I think that's more or less what made him want to leave more than anything else, was him hearing the sirens.
Okay. And did you see what happened after he went outside?
No.
Okay. You just know that police came?
Yeah,
Okay.
that did not take place in front of our store.
Okay, thank you. That's all I have, Judge.
I guess actually we go back to Mr. Conrad here.
Do you know the name of the individual that came in?
I was told his name was Manuel Ellis. I did not know his name at the time, did not know of the name until just of recently.
Okay. No further questions.
Nothing further? Okay.
Okay, Mr. Jones, thank you very much. You're excused.
Thank you.
Okay, next witness.
Next, Your Honor, we're going to call Deputy Wolf.
Thank you. Yes, sir, please come forward to right about here. And then please raise your right hand to be sworn.
Yes, Your Honor.
Solemnly swear or affirm that your testimony in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you very much. Please have a seat right here. Please state your name and please spell your name.
My name is Deputy Aaron Wolfe, Arronwolfe.
I'm sorry, can you say spell the last name again?
Wolfe, Your Honor.
Thank you very much. Mr. Conrad.
Good morning, still, Deputy Wolf. I'm gonna ask you some background questions quickly. Your uniform might give it away, but what do you do for occupation?
I'm a deputy with the Pierce County Sheriff's Department.
And how long have you been doing that?
Just under 6 years.
Ever worked for any other departments?
No, sir.
And what's your educational background?
I have any associates.
Okay. And I wanted to ask you about an incident on September 21st, 2019. Were you working as a uniformed deputy on that date?
I was, sir.
And did you respond to a dispatch call at the A&W store Pacific Avenue?
Yes, I was responding to that.
Okay, and can you tell the jury what the dispatch call was for?
There was a dispatch call for, excuse me, a strong armed robbery or a armed robbery. A black male had come into the A&W restaurant. I believe it's the 14500 block of Pacific Avenue South. The suspect was wearing camo pants, no shirt. He was bald-headed, and I believe he had a belt wrapped around his hand that he was trying to use as a weapon. He tried to strong-arm the clerk, and a fight ensued to get the money from the cash register. By the time that I had gotten wind of this, the suspect was not on scene, somewhere in the area, and I was en route to that from Pacific Avenue.
Did you have a partner with you that day?
I did.
And who was your partner?
Deputy Aaron Hoisington.
Okay. And did you respond to the scene with lights and siren?
No, we were far enough away that I knew that there was another deputy that was closer to the restaurant, so they were going to gain the probable cause there. And as far as I remember, we were driving, trying to keep our eyes peeled for possible suspects in the area.
Okay. And did you draft a report as well regarding your involvement?
I did.
If you need to refer to it at any point, just let me know. Okay?
Sure. Thank you.
Okay. And so what did you do in terms of responding to this incident?
We were driving southbound on Pacific Avenue towards the A&W restaurant, probably in the 13500 block of Pacific Avenue. And I was in the passenger seat, Deputy Hoisington was driving, and looking out to the left and right of the vehicle, and saw the suspect running northbound on Pacific Avenue, in the right-hand lane of the northbound lane. He was butt naked, except for white socks and a gold chain. Had blood coming out of his head, and it looked like he was panting and breathing very heavily. Under the streetlights, it was just a mixture of blood and sweat coming from his head. And so I told Deputy Hoisington to turn around, and that was probably our guy. Let's see. So we flipped around for northbound lanes and activated lights and spotlights, and conducted a high-risk stop.
Okay. And sorry, what time of night was it again?
I believe it was 8 p.m.
Okay. And where exactly did you see this individual first? Was it in the street?
Yes, in between running into the road, the bike lane wasn't exactly a straight path, but it was definitely a fast glimpse of, hey, why is there a naked man running down the street? And it also matched our description of our suspect.
And what street was it?
Pacific Avenue South.
Okay.
Yes, sir.
And were there any other officers on scene at that point?
Not yet.
Okay. And what did you do after you pulled over with your emergency lights on?
Advised dispatch that we're out with a potential suspect and to get more units en route to me. I stepped out of my passenger side, produced my firearm into a low ready position, and commanded the suspect to get down on the ground and stop, and that we were the police.
And what was his response to that?
Pretty quickly, he turned around. Eyes were huge, covered in sweat still and blood, but he immediately complied and laid down very quickly. So plan was to continue to contain him at gunpoint until we could get more officers or more deputies on scene, and then get him into detention.
And did other officers eventually arrive?
They did. They did.
Do you remember about how many other deputies arrived on scene?
First there was only one, and he was standing off to my right. And then a second one arrived shortly after the conclusion of that event. And then I believe more units arrived to just see what was going on at the end.
So you had four deputies on scene at a certain point, is that right?
Yes, sir.
So what did you do after you ordered this individual to the ground?
I yelled at him to stay down on the ground. I advised my partner, Deputy Hoisington, to go ahead and put gloves on to protect himself from the blood, and that he was going to be administering the handcuffs when we were able to get compliant handcuffing. But as I was standing there with him at gunpoint, the suspect hopped up and ran at me. Took probably 3 steps. I screamed at him to get down on the ground again, and he got back down on the pavement.
Okay. And were other officers giving commands as well to the suspect?
Yes, Deputy Bull had arrived right around that point to my far right, or not my far right, just off my right shoulder, and he was yelling at him to stay on the ground as well.
And what was this individual's reaction to those commands?
The commands initially jumped back down on the ground, heavy breathing, mostly excited utterances of like a gasp or a moan or things like that. I tried to de-escalate him in bits of, I was like, hey, what's your name? He told me that his name was Manuel Ellis. I said, hey man, just sit tight, spread your arms out like an airplane, just lay your chest basically on the pavement.
And what's your distance to this individual?
May I see my report?
I'm handing you what's been marked as Defense Exhibit 2511.
Thank you. Okay. I believe from my recollection, he was, at initial contact, he was probably 25 yards away from me. Once he was down on the ground and then started to make movements towards us, the first push up and then little sprint to us, I believe he was anywhere within 17 yards at that point.
Okay. So you are making commands to him to spread, you said spread out like an airplane.
Yes, sir.
And what was his reaction then to those commands? What did you do next?
We're still waiting on more officers because we only had 3 at that point. Trying to de-escalate him with talking to him. Didn't seem to really be sticking other than when he told me his name. And then just as, what was it? Just as we were kind of formulating a plan, Deputy Bull advised me that he was going to have less than lethal cover with his taser. And at that point, the suspect jumped up and sprinted directly at us, directly at my passenger side door, basically where all the commands were coming from. He sprinted directly at us. At that point, I knew that there was probable cause or reasonable suspicion, at least, to arrest this person for armed robbery, and this was our suspect. And so I pointed my gun in, and I started to gain proper posture to shoot center mass, just in case he, was able to take our firearm or do any other harm, kind of thing. By that point, he was reaching my front bumper of my patrol car. So from that position to my position was anywhere from 4 to 5 feet. I hesitated, and at that point, Deputy Bull's taser shot out and hit the suspect in the chest, which made him drop to the ground.
Okay. And you all were on the passenger side of the vehicle, is that right?
Myself and Deputy Bull were, Deputy Hoisington was still on the driver's side of the car.
And what direction did this individual run to?
He ran south towards the passenger side.
Towards your direction?
Yes.
And were you giving commands to him throughout this interaction?
Yes.
What was his response then to being tased?
It was a quick hit to his chest, so there was good contact. I wasn't going to believe that the taser was going to work, just with how amplified he was. It was pretty apparent that he had taken some type of narcotic, and his first after first contact, he had landed right basically at my feet between me and Deputy Bull. At that point, I jumped onto his back, putting a leg onto his shoulder and trying to grab an arm. And then I believe Deputy Lampton was arriving at that point, which he jumped onto the other side of the suspect's back, working for an arm.
And were you successful?
Initially, no. He's very strong. So Deputy Bull had to use the taser again through the prongs that were already set in position from the first shot. At that point, he was able to be manipulated into a handcuffing position, and Deputy Lampton put on the handcuffs.
And do you remember how many officers it took in order to get him into handcuffs?
I believe 3 of us.
And you said that he appeared to be under the influence of some type of narcotic. How could you tell?
Very wide eyes, overheating, breathing heavily, grunts, excitable utterances, sweating profusely, not listening to commands. Whenever he was on the ground, whenever I put my shoulder down on him, he was recovering from the taser almost immediately. I've been tased before, and it feels like you do about 1,000 crunches or abs sit-ups in about a minute. So you're very tired from it. He almost recovered from it immediately. And when I got down on top of him, I could feel him lifting me back up before the second application hit, and we were able to manipulate him.
And are you aware if, well, I'm going to show you, we just showed the witness, exhibit 251. Deputy Wolf, there should be something appearing if this tech works right on your screen here in a second.
It's saying HDMI no signal. Oh, we got something now.
This is 523,
This is 2513.
251. You can say something's on the screen, but it's not playing.
It's not on this screen.
No, it's just a desktop here.
There's just a desktop on this one. This is fun. Alright, well while we're figuring that out, things moving. So did Mr. Ellis have any injuries prior to your arrival or prior to your contact?
Yes.
And what were those injuries?
He had roughly 3 to 4 deep lacerations to the top of his head, and it seemed like there was swelling to the side of his head as well.
Okay. And what did you do after you were able to get handcuffs on?
We immediately called for a fire response for him to get loaded into an ambulance and taken to a hospital.
And did you have any further discussions with this individual?
No, I don't believe so.
Okay. And while you were waiting for fire to arrive, was this individual compliant?
Roughly. He didn't seem like he was really cognizant of where he was. Still, it seemed like he is finally getting exhausted. But he was in handcuffs. We were in between basically the bike lane and the curb and my car. So we left him just right there. It's a very tight place to be able to move around him. But yeah.
And you said that the individual identified themselves as Manuel Ellis, is that right?
Yes.
And did you have so you didn't have any discussion with him about what had occurred or anything like that prior?
No.
Okay. And what further contact did you have with him throughout the incident?
I believe I assisted with loading him onto the gurney when Central Pierce Fire Department showed up, and then providing cover while he was released to them.
Okay.
I got the video up on here now.
Oh. So, do you recognize Defense Exhibit, I think it's 2513,
I do.
and how do you recognize it?
About spring of 2020, I was notified by a coworker that, well, I guess it was before then. I think the winter of 2019, I was notified by a coworker that there was a video of the incident that I had with Manuel Ellis.
Okay. And have you had an opportunity to review it?
I have.
And is 2513 the same video you've reviewed?
Yes.
And is it a fair and accurate depiction of the incident and arrest of Mr. Ellis on September 21st, 2019?
Yes.
Your Honor, I'm going to offer Exhibit 2513.
What are your additional seats for objection?
Any objection to foundation?
On the audio, yes, Your Honor, on the video, without the audio.
All right. Objection overruled. 2-5. Any objection from any of the other defendants?
No objection.
Okay. 2513 will be admitted.
Permission to publish, Your Honor.
Proceed.
And can you kind of walk through with the jury what, and if it's helpful, maybe come down.
Mr. Connor, can you do it from the please?
And can you walk through exactly kind of the vantage point of what's going on here?
Absolutely. So this is a recording of our contact with Mr. Ellis. Through that red car is my patrol car. That's going to be the driver's side. I will be on the opposite side. Deputy Hoisington will be on the driver's side. We will be facing northbound on Pacific Avenue, and Manuel Ellis will be that figure right there behind the red car's bumper.
This figure, what, I don't, the figure right by the red car bumper here, is that right?
Yes.
You want him to use a pointer to point it?
Sure, please, could you step down?
Yeah, absolutely. So this, as I was saying, this was my patrol car here with the emergency lights activated. I believe this would be on the west side of where the incident is. This is Manuel Ellis right here, and this is Pacific Avenue South. Basically where we were parked, we were butted up against this curb that ran down the side of the stateroom.
Okay, I'm gonna ask you to just play through it once and then maybe walk through it after.
This dude is butt naked. He was running down Pacific. Looks like he got tased. Yep, he got tased. Party's over. Only in Tacoma.
So can we go back to the beginning, the very beginning of that?
Well, it's now 11:59. So we're allowed to do all this, I suppose, so we'll take our noon recess this time. Ladies and gentlemen, discuss a case among yourselves with anyone else. Do not permit anyone to discuss a case with you or in your presence, and we will be back, please, by 1:15, and to try to resume as soon as we can thereafter. Thank you.